Well, hello everyone. This is Betty Meredith, President of the International Retirement Resource Center, and I'm happy to be your session host today for the DOL Fiduciary Rule and Your Duty of Care with Blaine Aiken, AIFA, CFA, CFP, Executive Chair and Executive Chairman of FI 360 as our session presenter today. For our introduction to this program, I'm going to read an excerpt from a blog called The Nerd's Eye View, published by Michael Kitces, who is a popular writer and speaker in the financial planning industry. Earlier this year, he wrote a post about the fiduciary duty of care, and it was this thought that made me reach out to Blaine to address us today. In one of his posts, Michael said, quote, "The reality is that being a fiduciary actually entails two core duties. The first is the duty of loyalty, in other words, to act in the client's best interest. And the second is the duty of care, to provide diligent and prudent advice, and only in areas in which the advisor is competent to provide such advice. After all, a fiduciary obligation is relatively meaningless with only a duty of loyalty if there's no expectation of competency." So in other words, it's necessary that advisors and financial services companies make sure that people even know what the best advice for the client is in the first place, which is why we do these monthly retirement-specific webinars and why we started all this 5 years ago. So our speaker today is Blaine Aiken. He's a well-recognized thought leader in the field of financial advice and fiduciary responsibility. Blaine joined FI 360 in 2005 as the Chief Knowledge Officer, became Chief Executive Officer in 2007, and was named the Executive Chairman in 2015. He led the rise to prominence of the company's professional development capabilities, their investment management platform for advisors, and business and research management practice management services that help advisors and financial institutions profitably gather, grow, and protect investor assets. He has extensive experience, which includes having been a financial planning practitioner, a chief investment officer, and a corporate executive responsible for the design, delivery, and management of investment products. Blaine is also a well-known speaker and author of numerous articles on the subject of fiduciary responsibility and investment management. He authors a monthly Fiduciary Corner column in Investment News magazine and has been named to Investment Advisor magazine's list of the 25 most influential people in the investment advisory community. He's also been named as one of the 10 most influential individuals in the 401k industry by RIA Biz. And currently, his big responsibility is the chair of the board of directors for the CFP Board of Standards. So Blaine, again, is a CFP, a CFA charter holder, and of course, an accredited investment fiduciary analyst, the AIFA designee. So welcome, Blaine. Thank you for being here with us today, and I'll now turn it over to you.
I'm very happy to be here, Betty, and appreciate the introduction. So let me just hit the topics that we'll cover in the next hour here. First, I thought it would always a good idea to start with why did the DOL act? And so here we'll look at a little bit of the historical perspective of the fiduciary responsibility generally, but then specifically the motivation behind the DOL conflict of interest rule, or the fiduciary rule as it's also known. And then we'll explore how the rule actually works. And of course, there's been a great deal of activity around the rule ever since it was introduced. So we'll give you an update on where the rule stands now, and then move on to talk about what specifically you need to do to comply with the rule as an investment advisor. Now, I understand we have non-investment advisors that are listening in today as well. And so here is where we have an opportunity to at least provide some additional understanding of what's behind the rule and who this applies to. And then finally, we'll close out by talking a little bit about going beyond compliance. And it seems like sometimes we get a little bit too heavily involved in the regulatory side, and we can think a little bit more about the fiduciary advice as a profession. So with that, let's talk about why did the DOL actually take action? And this is a place where I typically like to start. This is a very famous quote from the Supreme Court Justice Benjamin Cardozo. And he talks about the difference between fiduciary standards versus rules of the marketplace. a trustee, and whenever he talks about trustee, that's kind of the classic way of thinking about a fiduciary. It's someone who holds assets on behalf of another. So a trustee is held to something stricter than the morals of the marketplace. Uncompromising rigidity has been the attitude of courts of equity whenever they're petitioned to undermine this undivided duty of loyalty that we'll talk about in a moment. And a key phrase here is he mentions the disintegrating erosion of particular exceptions. And so by avoiding those exceptions, we're able to keep the standards for fiduciary higher than the standard or the morals of the marketplace. So what are those morals of the marketplace versus the fiduciary standard? And here, this table, I think, captures the essence of the difference between the two. When we're talking about the rules of the marketplace, we're really talking about counterparty transactions. So what that means is the relationship involved is one that we classically think about in a transaction where it's very much arm's length. And so if you're going into a transaction with someone else, you typically know that there are conflicts involved. Both parties are trying to serve their own self-interests, and typically the sophistication gap is relatively narrow. So the buyer can beware here, and this is like whenever you go in and you're shopping for a car. It's not that complicated to do the research on cars, and whenever you go into the showroom, you know that there's somebody on the other side of the transaction that you're talking about. So the standard of care is the rules of the marketplace. It's suitability based. It's really a product protection type of regulation as opposed to something more significant. And it's often very rules based, where it's highly specific. Thou shalt do this or you shall not do that. When we're talking about personalized advice in that column on the right-hand side, this is the fiduciary relationship that Cardozo was talking about, where we have a trustee, someone who is responsible for taking control, effective control of the assets of the individual, who in this case would be the trustor, the one who is giving up some measure of control to the trusted advisor. So in that circumstance, conflicts have to be resolved in the client's interest, because the sophistication gap, the information balance is very much disproportionate. So you have a relationship of control and reliance with high vulnerability on the part of the client as opposed to a regular counterparty transaction. So that's why we have a fiduciary requirement. It's not only suitability, it also requires the prudent person rule to come into play. And this is what Betty was talking about in particular. It's not just duty of loyalty, it's duty of care, and the prudent person rule is something we're going to be talking a good bit about. And it's highly principles based. It's the idea that you are held to these two core standards, the duty of loyalty and duty of care.